21, and ask the Commission Secretary for information on today's agenda.
Each Commissioner has independently reviewed the minutes of the open meeting of Thursday, December 9th, 2021. Each is informed to discuss those minutes.
Move we approve the minutes of Thursday, December 9th, 2021.
Second.
All in favor?
Aye.
Aye.
Each Commissioner has independently reviewed the agenda. There's no need to discuss the notice associated with Agenda Item 2. The draft final decision in Docket 5 AE 224 associated with Agenda Item 3. The draft final decision in Docket 5 AE 228 associated with Agenda Item 4. The suggested minute associated with Agenda Item 6, setting a deferral end date as of December 31, 2021 for all deferrals previously authorized in this docket, ending the current required quarterly reporting frequency and requiring a final survey covering the period from the last quarterly survey completed through December 31, 2021, requiring utilities to file a rate application within a 1 to 2 year period from the date of the Commission order requiring such rate application for any utility that would like to request recovery of the reported COVID-19 financial impact, requiring utilities to write off the reported COVID-19 financial impact using a 3 to 5 year amortization period if they are not seeking recovery or did not request recovery by the Commission determined deadline, and requiring a true-up in the next rate proceeding for each utility that requests recovery of the reported COVID-19 financial impact. Or the suggested minute associated with Agenda Item 7, discontinuing the reporting requirement on reconstruction information in Docket 5 UI 120.
Move to approve the notice of investigation associated with Agenda Item 2.
Second.
All in favor?
Aye. For Agenda Item 3, Docket 5 AE 224, I move we approve the draft final decision.
Second.
All in favor?
Aye.
Aye. For Agenda Item 4, Docket 5 AE 228, I move we approve the draft final decision.
Second.
All in favor?
Aye.
Aye.
Aye. For Agenda Item 6, Docket 5 AF 105, move we set a deferral end date of December 31, 2021 for all deferrals previously authorized and the current required quarterly reporting frequency, require a final survey completed through December 31, require utilities to file a rate application within a 1 to 2 year period from the date of the Commission order. For my spot, Commission order require use of a rate application 1 period from the date of the Commission order requiring such rate application for any utility that would like to request recovery of the reported COVID-19 financial impact, requiring utilities to write off the reported COVID-19 financial impact using a 3 to 5 year amortization period if they are not seeking recovery or did not request recovery by the Commission determined deadline, and then finally requiring a true-up in the next rate proceeding for each utility that requests recovery of the reported COVID-19 financial impact.
Second.
All in favor?
Aye.
Aye. Agenda Item 7, Docket 5 UI 120, move that we approve, discontinue the reporting requirement on arrears and collection information.
Second.
All in favor?
Aye.
Aye. Okay. That brings us to Agenda Item 5, which is Docket 9811-CE-100. This is various motions for interlocutory review and customary case. My understanding is that both of those motions have been deemed denied by law, but there was a request to have it on the agenda. So, by process of elimination, I know Commissioner
You are.
accused. So, Commissioner Nowak.
You get the award today, Chair Bach. You get the Sherlock Holmes Award. Yes. I did want to discuss it just because this is, a case that's getting a lot of attention. It's a lot of public interest and a lot of interveners, and I think it's important, at least from my standpoint, for the parties to hear my thoughts on some of the discovery issues that have been going on here. So while I do agree and understand that the pending motions have been deemed by operation of law and we could, still rule on them by reopening them under our motion, I'm not suggesting that, but I still want to have a discussion about what I would have done and address some other issues regarding representation. So I'm mostly just solely going to focus on the applicant's motion to compel. had we been in that time period, or had it not been basically moot because the discovery can commence again tomorrow, I would have issued an order granting their request. I think that the ALJ erred in denying that request, and I think the determination by the ALJ that it could have been handled, or it might have been handled throughout the testimony, was problematic and concerning. So, but again, because the discovery commences again tomorrow, I don't see that there is a point in issuing a formal order on that. The only thing I would say is that any issues that were not addressed in that testimony that the applicants still want to request and that are deemed relevant are still on the table, and that shouldn't be truncated in any fashion going forward. I think we need to have that best record moving forward on that. I do agree with the ALJ's decision to deny the intervener's motion. I felt that was without merit. The other thing that is concerning to me is the representation of some of the parties in this case. And I think it's important for us to get some clarification on what is happening with that, because this case is going to continue, I think, to get more complicated as it moves forward. And we can't have misunderstandings of who is representing whom and who the privilege applies to. That's just going to make our decision harder, which is very unfair to the public in general, right? So I think that we should, there's been at times where Attorney Jablonski has represented that he has a consulting agreement with some of the pro se interveners, but then at times he also has said he has an attorney-client relationship with them. You can't really have both. The consulting agreement and the privilege doesn't apply, in my understanding, when it's just between the parties and when there is a pro se intervener. So I think that, and they're entitled, we're all entitled, they can have whatever representation they want, but we need to know what it is going forward. So I think that if they want to claim privilege on certain communications, then we or the ALJ are entitled to see that privilege log and review it prior to, to determine if it truly is a privileged document. I think we need to have a transparent process here. So I would like, by the close of business next Wednesday, an explanation from Attorney Jablonski what his relationship is with the pro se interveners, and something from the pro se interveners themselves, so we understand what their relationship is. Because again, the request from the applicant was about communications between the parties themselves. So privilege doesn't attach to that, and they can't hide behind that. So I think we need to, like I said, this is all about building a good record for us to make a good decision. And again, everyone's entitled to whether represent themselves or not, but the rules, whether you represent yourself or you're represented by an attorney that bills $1,000 an hour, apply the same. Mm-hmm. And it has to be applied equally. So I would like to see something by, like I said, close of business next Wednesday on what is the nature of that relationship, and how he is assisting them. And if they are going to claim privilege on things, they're going to have to file a privilege log that will have to be reviewed going forward.
Yeah, I think that's reasonable. I was prepared to deny both. I was a little troubled, and they are denied because we're not doing anything. Mm-hmm. We're not taking any action. So they've been denied. I was troubled by the concept, two things. I was troubled by the concept of truncating discovery on the basis that it'll be picked up in direct testimony. Mm-hmm. That's a bad path to go down. Mm-hmm. Oftentimes what parties discover through the discovery process ends up being foundational to their testimony. Mm-hmm. So I don't want to give the impression that that's the proper path to go down. Where I landed was the exact same place that you did, and that is discovery commences again tomorrow. And so to the extent that the testimony didn't address some of the other issues that the applicants want to further investigate, that it's completely appropriate for them to serve discovery and that type of information. The second thing I found troublesome was exactly what you laid out, and that is this sort of cherry picking of, well, no, I'm just consulting, but common interest privilege applies, which it doesn't, because common interest privilege only applies amongst represented parties.
Right.
And it's really for the lawyers.
Right.
You know, at the end of the day, it's to make it more efficient for the lawyers to be able to represent their clients. So the common interest privilege does not apply. And then you don't, and we know this because we're lawyers, you don't get to pick and choose when you have an attorney-client relationship. It is very clear in our professional rules of conduct, and it is very clear in the rules from the Supreme Court what has to be followed. So that's all I'll say on that. But again, I would just encourage all the parties. The purpose of discovery is to get information, and I know that there have been a lot of back and forth related to discovery in this case in particular. And I'll just reiterate what we say all the time. The best records are the records that reflect the best information. And one of the ways to go about getting really good information is through the discovery process. So I don't want us to be at all, I don't want the inference to be that this body shies away from discovery. That's not the case.
Yeah, but I also want to make sure that, you know, if they are truly the same, have the same exact interests, then why are they separate? And is it just for the purpose of having a lot more discovery and then confusing the record? Right. So I'm troubled by that type of thing. So do we need a motion?
Well, the one suggestion I might have, we're getting into kind of the internal operations of the procedure and privilege logs and things like that. If maybe the most appropriate course is the ALJ, I'm sure, is listening at this point in time, and that the minutes reflect that we've provided direction to the administrative law judge to proceed to obtain the information relating to the status of the representation, and then following up if needed with privilege logs and further directives necessary.
So will he issue an order having them file something?
I can, if we do that's fine. Otherwise, we will have the minute.
Okay.
But I think we are getting into sort of those proceedings that it may make more sense to have it be handled by the administrative law judge.
That's fine with me. Do we need a motion?
No, I don't think we need a motion. Again, you've discussed it. We're not taking action per se on the motion. You're providing direction to the administrative law judge to implement activities consistent with your discussion.
Okay.
And I'll just state for clarity, Commissioner Huebner, I am recused on this docket.
Yep. Okay. Thank you. Okay. Then we can move on to agenda item 8, which is docket 9801-CE-100. This is the application for a certificate of public convenience and necessity of Paris Solar Farm. There's a request by them to expand the conditionally approved battery storage system size, and Commissioner Huebner is going to lead the discussion.
Great, thank you, Chair. A brief background. So on December 29th of 2020, and as corrected in April based on a naming change, we issued a final decision in this docket providing authority to construct a solar photovoltaic generating facility, 200 megawatts of alternating current. It also conditionally authorized a 50 megawatt AC battery energy storage system. We had, however, a condition related to that battery storage system that the applicant report back with their MISO definitive planning phase studies and provide the Commission with final detailed engineering plans for the battery storage system. About half a year later, on May 28th of 2021, the applicant submitted a request for the Commission to reopen the docket, seeking approval for an additional 60 megawatts of battery energy storage, saying that that would maximize the potential capacity accreditation of its MISO position, and other reasons were described. On June 28th, we issued an order granting that request for a limited reopening, and we directed the staff to complete a supplemental environmental assessment and prepare the memo that we have in front of us. So in the process of the supplemental EA, we received comments from about 13 individuals. The supplemental EA looked at the endangered and historic resources, land use, local government impacts, noise, and wetland and waterway impacts, among other areas. They determined that the preparation of a EIS, an environmental impact statement, wasn't needed. There's minimal, if any, changes to the endangered and historic resources, stormwater. And stormwater impacts will need DNR permits as per usual. And then there's a couple potential conditions related to noise and safety that we can discuss. So that's my run-up to page 13 of the memo, which gets into our decision items. And I would be at alternative 2 related to the request to conditionally approve and expand the battery energy storage system from 50 to 110 megawatts. I think the discussion, and obviously this is also a merchant facility still, so we're not looking at the economics as we have been in this case historically. So I think the EA did a very good job, supplemental EA, of describing the additional impacts. We'll talk a little bit about noise and safety in a couple minutes, but overall, I was at alternative 2, that this has met the requirements, and I would approve the additional 60 megawatts. So Chair Bach.
I was also there, and it was mostly because of the rules related to the signed generator interconnection agreement, that it really, because of the way capacity is accredited by MISO, the math works out so that it's not actually as big of an increase as it would seem on its face. And I thought that the memo did a really good job of laying out why that is. And so I was also at alternative 2.
Okay. Commissioner Nowak?
Yeah, without belaboring it more, for the reasons you guys said, I'm at alternative 2.
Okay. One of the things that we wanted to take a look at was our order condition number 13 language, and on this I am also at alternative 2, which would essentially update that language to reflect the 50 megawatts original plus the additional 60, and still give us the opportunity and staff to review the final detailed engineering plans and raise any issues up if those are identified in that process. So I would remain at alternative 2 on this.
I agree. I'm there as well.
I agree.
Okay. So related to order conditions related to potential environmental impacts, staff, I thought, again, the environmental assessment was very well done. It was good to see some public comments in that, and I know the town of Paris also put in a comment with some of their concerns, so we really appreciate that input. On this one, I continue to think that, well, number one, I found the information provided about the technology for the battery energy storage, why this is different than the technology that was used in the fire that we saw in Arizona, and some of those concerns that were raised when we originally approved this. I think there's a lot of excellent information here. I continue to think that us just having that due diligence is really important. So I know the applicant put in comments saying they will have an established protocol. I think it behooves our staff to have that on file prior to the operation of the battery storage system. So I would support sub-alternative A, to have that established protocol prior to operation is where that's the timing I would use, and to have that provided to the commission prior to operation. I would not support sub-alternative B, and the reason is because I'm seeing this from the local government's perspective as essentially a trade-off. The noise impacts versus what's it going to take to ameliorate the noise. And the sound study that was done talked about a 20-foot sound barrier. And so putting myself in those shoes of those local residents, do you want maybe a decibel or two above 45 dBA, or do you want a 20-foot noise wall? And I think that that's going to really be working with the local government and working with those residents, to me. So I would not approve sub-alternative B, because I think that there's various trade-offs that are going to have to be discussed and worked out. So sub-alternative C I would include, because again, I think from my perspective, the battery energy storage technology is new, and just having additional information, or if something were to happen, how can we avoid that in the future? Because this isn't the only application that has battery energy storage that will come before us in the future. So to reiterate, then I would be at subalternative A with prior to operation, and I would be at subalternative C. Chair Box.
Okay, thank you. I am also at alternative 1, but the only one that I would include would be subalternative C, and I would modify that. So the comments that Harris Solar, continues to work with town officials, I thought gave me comfort. And as you indicated for subalternative B, Commissioner Huebner, I think that same rationale, at least for me, applies to subalt A. What I do think about subalt C is that I think just requiring a report on any incident within 60 days of that incident to us is sufficient, not because we would necessarily do something with it in this particular case, but because of the emerging nature of the technology that we're talking about, it could inform changes or the conditions that we would use in the future. So I would modify subalt C to simply have the applicant provide reporting on any safety incidents at the storage facility within 60 days of the incident to allow for future consideration of best practices. So I would stop at that.
Okay. And I will join you at that 60 days. Fine. Commissioner Nowak?
It's fun because we're all in different spots on all of them. I was okay with A as long as we clarified that it's a reporting requirement policy. Like, I don't want us involved in the plan.
Yeah.
We don't review it. It should just be on file, just in case we get, if, heaven forbid something does go wrong, we know what is going on, because we'll get calls too about it. And it's just more of an FYI, definitely not something that I think, let them work it out and then just file a copy with us.
Were you fine with this prior to operation caveat?
Yeah. Yeah, I would think it should be done before they start it up. On B, they had committed to doing that in their reply or response. But I don't have strong feelings, because if there is a better way to work it out with the locals, more power to them. So I will join you guys then on just saying work it out with the locals on how to reduce the mitigation of the noise. But I think it is an important thing to do, since we will probably be seeing more of these. And then on C, I thought it was a little broad, the way it was drafted. And much like A, it's more for just FYI, not that we can enforce or do anything, because they have other enforcement and codes that they have to comply with. But it says at the system and any safety incidents. So I don't want us to know, like, when someone falls or cuts their finger with a knife, or I don't care. Care.
Hope it doesn't happen.
Yeah, but that's not the stuff that we're looking at here, right? So yeah, I hope it never happens. So I'm fine with the reporting within 60 days, again, just for reporting purposes, but anything that triggers the protocols in the ERP is what I would have them report. Because that's kind of the theme of the stuff anyway.
So safety incidents that trigger the ERP.
And
it makes it technology specific and not trips and falls.
Right.
Yep.
Right.
Yep.
I'm fine with that.
As am I.
Okay.
And I'll join you both at subalt A.
Okay.
Cindy, do you have what you need on?
Just one follow-up. There was for future consideration of best practices that the chair had put. Are you fine with that?
It is in there. I just propose to keep it in there.
Right.
Yeah.
Bless you. Well, that's just part of the reporting, informational purposes part of it. Yeah.
Right. Yep. Okay. Nope, I've got it. Thank you.
Okay, that brings us to our final decision item, which is the environmental review, and I'm at alternative 1, that the commission has complied with LEPA pursuant to with stats 1.11 and our administrative code PSC 4.
I agree, all one.
I agree.
Okay. Then I'll take a motion, Mr. Nowak.
To move in docket 9801 CE 100, the commission approves with conditions and pursuant to our discussion, the request of Paris Solar Energy to expand the battery energy storage system from 50 megawatts to 110 megawatts.
Second.
All in favor?
Aye.
Aye.
Right. That brings us to docket 2820-WR-107. This is the application of the City of Kenosha as a water public utility for authority to adjust the water rates, and I understand from the Commission Secretary that there's no need for us to discuss the uncontested issues. So as a, let me get through the intro and then I'll raise kind of the preliminary procedural issue. On October 9th, 2020, Kenosha Water Utility filed an application to adjust water rates, requesting an overall increase in annual revenues of approximately 11.31% over present revenues. The Village of Pleasant Prairie Water Utility was requested and was granted intervention, and those are the only two parties to this proceeding. Then fast forward about a year later, and both of the parties informed the Commission that they had reached an agreement with one another for a full settlement of all of the contested issues, including agreement on the revenue requirement and the cost of service. And they indicated that they would present an executed settlement agreement and that agreed upon cost of service at their hearing along with any additional testimony. And so at hearing, that settlement agreement was offered, it was accepted into the record. And then there was a question about, does the settlement law apply? Mm-hmm. So issues 1 through 4, deal with the specific statutory provision of the settlement law. As this is a case of first impression where we just have two parties entering into an agreement, I want to be very careful and I want to make it clear that while I find the agreement that the parties entered into to be reasonable, and I will be voting to approve that agreement, I did not base that conclusion, nor did I evaluate the agreement under the settlement statute, because I don't think it applies here. Now, I know that there was also something in the brief that said, if you're going to go down the road of applying the settlement statute, this is why it comports with the settlement statute. But just as an initial matter, I find the resulting agreement to be reasonable, and I find that it results in rates that are just and reasonable, but I didn't base that analysis on the settlement law. So I'm going to pause there and see if either of you have any comments, because like I said, issues 1 through 4 deal specifically with the settlement law. So I think from my perspective, that means I'm going to be sort of punting on deciding issues 1 through 4. Mm-hmm. So, Commissioner Noel.
Yeah, this was interesting. They realized after they got through it, like, oh, we've settled, so let's write up a settlement. And I get why they did that, and I think there is some confusion of whether it had to be done, what it must be done, and presented to us. But there was also a question that, well, there's just two parties, and can it really be, the question is, we meet the criteria specifically under 7B of the settlement law, the public interest adequately represented, because the Citizens Utility Board in particular wasn't a party. And I will be, I'm very clear in my head that has no bearing on it at all, because if we're just going to say you can't settle if Cub doesn't be a party, then that's not good. And that is not what the intent of the law was, again, too, because you can't then just basically let one entity hold settlements hostage by either participating or not. Because even in the settlement law, if one holds out and says, no, we can still approve a settlement. And just because Cub, by their charter says they represent all citizens, I don't know that just because of their participation that every resident and ratepayer of the state said they do represent them. So their lack of participation here had zero bearing on how I proceeded in this case. But ultimately, I ended up in the same spot with you as, why don't we just treat this as a rate case with, a few issues that were brought up, uncontested with the parties, but staff brought things to us. And I think we reach it, I think it's the same end result. I can surmise maybe again why they brought it as a settlement, as a package, but I think if we proceed under all the other host of things we can do under 196, 2237, 395, all those other, we just treat this as a regular rate case. It's the same result in the end. That's my preference as well. So I would acknowledge the settlement agreement in there and thank them for doing it, but I think we just proceed under our regular statutory authority.
I agree. And I agree with the point that you raised about, the absence of one particular organization does not make or break it.
Yeah.
That's not the intent of the law.
Yeah.
That's a good point. Commissioner Huber?
Yeah, I ended up in the same spot, or maybe started in the same spot as well in my briefing, is say, how do we know that, and not necessarily Cub, but some group of citizens some group of representative ratepayers of these organizations. And I landed in the same spot that we essentially punt on the question of, does this comport or does the settlement law as it's written apply, but understand that the details of the settlement agreement are supported by the record. They're within the range of what had been the whole litany of testimony rounds. The settlement ended up within those exact bounds. And so we can look at this and determine that the rates are just and reasonable. Settlement is still appreciated, but we don't need to sort of bound or unbound ourselves to how we're going to apply that settlement law in this particular situation. So thank you.
Okay, great. All right, so we jump to issue 4A. Which is on page 8 of our decision matrix, and the issue is, should the commission include commission staff's adjustments to account 673 in the final revenue requirement approved in this proceeding? So this has to do with what average should be used when you make the calculation to go to looking at the forward test years. Kenosha put forward a 3-year average, and they excluded 2020 because of the pandemic. Commission staff provided testimony that used a 4-year historical average. And I think in this particular case, I was persuaded by the applicant's argument as to why they used the estimate that they did. And I think that accounting for the pandemic is appropriate, and they submitted testimony that going forward, what they're expected to see in terms of breakage. So I was at alternative 2 for this. I would not include that proposed adjustment. Commissioner Noir?
Yeah, I agree. I thought the testimony from the applicant was more persuasive here, and 3-year was better. So alternative 2.
Commissioner Huber?
Yep, I landed at alternative 2 as well.
Okay. Issue 4B, should the commission include commission staff adjustments to account 923 and account 664 in the final revenue requirement? This one was an interesting one. This has to do with the overhead rate and the use of sewer employees to do utility work, and whether or not that's appropriate, and should they be hiring additional utility employees, should they be using contract employees. And I do appreciate, commission staff, Troy Gaza put forward a lot of testimony, and he asked a lot of really good questions. I think it's a relevant question to ask, and it's exactly the type of questions that we should be asking in this case. But for me, the information that was provided by the applicant justifies that revised amount. And the applicant did do a revision of that amount, so it's a little bit lower. It actually comes out to $358,421. And based on the evidence in the record and the considerable back and forth, in the end, I was persuaded by the applicant. So for this one, I'm going to go with alternative 3, and that alternative adjustment would be the one that was included in Kenosha's updated forecast. Commissioner Noy?
Yeah, this one probably got the most attention, and there was a lot of back and forth. I understand, too, where staff was trying to get at there, but I also felt that, again, here the utility had the stronger argument, and I understand from a business operations standpoint, I think they still come out, it's still a better deal for the ratepayers, even though there were a few details that weren't, totally fleshed out, but the concept itself is what I think wins the day, and like I said, their testimony was more persuasive. So I'm at alternative 3, their revised amount, $358.
Mr. Huebner?
I landed at the same spot, but I had a note, one of my sticky notes too, exactly what you said, Chair. I think our staff member, Troy Gaza, is doing exactly what we want to see, which is getting data and support for the numbers. I felt like by the time we got through the transcript and the SIR rebuttal, I had those. So I felt comfortable that we got to that point, and the points made by the applicant were sufficient to me, but I think Troy did a nice job to point that out, that the support wasn't there initially, and to work to the point where we got it. So I'm at alternative.
All right, so then we jump to issue 5, which is the Kenosha customer side lead service line financial assistance program. Is the amount that they included reasonable? In our decision matrix at page 14, it says that we may wish to defer a decision on the reasonableness of this until we review 5A and 5B. But then when you go to 5A and 5B, they're both uncontested.
Yeah.
So,
yeah.
Well, 5B is not.
So,
no.
I mean,
Kinda.
you can make a decision, but yeah.
Yeah. Okay. Well, 5A is uncontested.
Yeah.
So, I am, for issue 5, I'm going to stay in order this time. Issue 5, I'm at alt 1. I don't think we need to jump to 5A and 5B. So for issue 5, I'm at alternative 1.
Yeah, I'm with you there. Okay.
I'm going to come back to it after we talk about 5B.
Okay.
That's okay.
All right, so 5A is uncontested.
Yep.
5B, should the commission include lead tap sampling costs in the final revenue requirement for the lead service line program costs? So there was testimony on whether or not this could be construed as discriminatory. The applicant is proposing to include about $18,000 for lead tap sample testing in homes that they believe are likely to have a lead service line. And again, this is an issue where RJ, brought this up in testimony, and I think it's a valid point that he brought out. However, I think that Kenosha is the uniquely positioned party to know which homes will likely be impacted by lead service lines. And so for this, I actually thought it was reasonable to include these costs in their final revenue requirement. So at the end of the day, I was persuaded by the testimony given by the applicant, which leads me to alternative 1. So I would include that in the revenue requirement.
Yeah, I agree. I mean, this always gets into, are we subsidizing costs that should be borne by a particular ratepayer or not? But we've kind of crossed that bar in this lead sample testing. But I agree with you that if anyone's got to know the people, we should leave it up to the local utility to deal with their customers. And they did, I think, modify it so that it would only be done upon customer request. So I think this is a very reasonable thing for the utility to offer to its customers. Again, they know where the lead laterals may be. So I'm fine with leaving it in.
Okay. Commissioner Huebner?
Yeah, and I was fine with including the costs, as you both said, and I guess my question was going to be about if a customer wants to have that test done, but they're not in that area identified, and that's kind of what alternative 3 allows for is, and there's no dollar amount added to that, so I think that puts us in a little bit of a strange situation, but I guess I was open to the idea of alt 3, and that's why I wanted to have the discussion on that, because I guess the question is if a customer may not be in that area that Kenosha Water Utility knows, but still wants to have some peace of mind about a lead test, should that be allowed? I didn't know if you had any thoughts on that, or just something that we can continue to work with the utility going forward too. So
Yeah, and I think that I would leave it up to the utility, right? I mean, I would be hard pressed to say that they're going to be turning people away. I think that this is a bucket of dollars that they have identified an area that has a high likelihood.
Yep.
But I wasn't concerned about
the
people being
discrimination
turned
or
away.
anything.
Yeah, yeah. So I was, and I think that this is a reasonable first step.
Yeah.
And then, as you indicated, Commissioner Huebner, if we go down the path of all three, then we're talking. I mean,
well, then people who, even if they have a newer home, I just want to be sure,
Right.
and we can't go down that road.
Right.
I mean, there is a defined, time when these were used. The
Right.
utility knows, they know the areas.
Right.
We shouldn't open up to having the water utility become a testing facility for everybody either.
Yeah.
I think this is a reasonable.
Okay. So I'm going to join you at Alt 1, and then that will put me at Alt 1 for the broader issue 5 as well.
Okay.
Thanks.
Issue 6 is the cost of service study agreed to. This is kind of the same issue where the later issues are uncontested. So for the cost of service study, I was at alternative 1.
Mm-hmm.
Yeah, Commissioner Owens, no, Commissioner.
I'm at alternative 1.
Okay. Uncontested.
I don't think there's any.
So then there's issue 7. Oh, it's uncontested.
I don't think there's any left.
I don't think there are either.
Is there left? The conditions? Yep.
Right?
11. 12.
Yep, okay. So we jump to issue 11. And again, this ties back to the settlement statute, right?
You know, do it. Yeah.
Right. So we don't need to make a decision on this because we're not applying the settlement law. So then we jump to conditions, which is issue 12. Those are what general conditions that are typically included should be. In this case, and for this one, I was at alternative 2, which is all of the standard conditions.
Mm-hmm. Yep, 2 with all of them. Yep.
I'm at the same spot, alternative 2.
Okay. All right.
You guys ready?
Okay. Denise? Okay. All right.
Then I will move in docket 2820 WR107, the application of the City of Kenosha as a water public utility for authority to adjust water rates consistent with our discussion today.
Second.
All in favor?
Aye.
Aye. Okay, that concludes our official business for today. Our next open meeting is scheduled for, wait for it, Wednesday, January 5th, 2022 at 10:30. So no change in date, it's a Wednesday. And we have a couple weeks off. So I want to thank my colleagues and staff for really, really productive 2021. We had a huge volume this year, a lot of different cases, a lot of work. And I want to wish you all a very happy and healthy Christmas and a very, very prosperous 2022. So,
well said, yes. So I will move that we adjourn until January 5th, 2022.
All right.
Second.
All in favor?
Aye.
Aye.
We're adjourned. Thanks, everyone.